Get ready for the dictation. Start. Learned Counsel appearing for respondent number 3 thereafter drew the attention of the court to the various pleadings which were exchanged between the parties and submitted that at no point of time the petitioner oblique employer had made any application for an opportunity to lead evidence or to prove the charges against the respondent number 3. Learned Counsel also submitted that the Special Appellate Court, which had passed the order dated 16/1/2012, had at no point of time forbidden the tribunal to decide the reference along with the decision of the issue with regard to the fact as to whether the respondent number 3 was a workman. Still further, Learned Counsel for respondent number 3 submitted that the labor court in the fitness of things had framed issues while passing the award which definitely guided it to come to a proper conclusion. In the end, Learned Counsel for respondent number 3 submitted that the petitioner oblique employer at no point of time had prayed that it be allowed to lead evidence to prove the charges against the respondent number 3. Having heard Learned Counsel for the petitioner and the Learned Counsel for the respondent number 3, the court finds that admittedly the Special Appellate Court had passed an order by which it had directed the labor court to first ascertain as to whether the respondent number 3 was a workman. Still further, the court finds that on 3/4/2019, the labor court had framed an issue by which it had concluded that initially, before answering the reference, it had to be seen as to whether respondent number 3 was a workman. Thereafter, the court finds that on various dates when the case was fixed, that is on 7/5/2019, 14/5/2019, 17/5/2019, 27/5/2019, 9/7/2019, 6/8/2019 and 17/9/2019, nowhere did the labor court insist on the parties to make submissions with regard to the merits of the case. The court finds that only on the last date, that is on 17/9/2019, the labor court had observed that in the presence of the parties, arguments were heard. It is not clear as to whether arguments were heard on the preliminary issue with regard to the fact as to whether the respondent number 3 was a workman or whether arguments were heard on the merits of the reference also. The order sheet, as has been annexed in the writ petition, also does not show that issues were framed by the labor court before the award was passed, and it is definitely not clear that the parties were made aware as to which of the issues would have to be addressed by the parties. When a matter is referred to the labor court by means of a reference, the parties are aware as to what has to be adjudicated upon in the case. However, when only the issue with regard to the determination of the fact as to whether respondent number 3 was a workman was being decided, it cannot be gleaned from the proceedings that the parties were ever made aware of the fact as to whether they were to address the labor court on merits also. Had the court, after ascertaining as to whether the respondent number 3 was a workman, directed the parties to make their submissions on merits, then no fault could have been found. However, in the instant case, the court found that on 3/4/2019, the issue with regard to the fact as to whether the respondent number 3 was a workman was framed and parties were required to make their submissions with regard to it alone. Thereafter, various dates were fixed and it was expected that the parties would make submissions on the issue framed on 3/4/2019 first. Still further, the court finds that nowhere in the order sheet the issues as had been enumerated in the award were framed, and therefore it cannot be concluded that the parties had sufficient notice as to in what regard that had to address the labor court. Stop.